Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Former immigration judge Ilyce Shugall has had many roles. On March 14th, she was gracious enough to come on the podcast and talk about him with me. During our extended conversation, the former judge and I talked about everything, from her early career fighting for non-citizens on the border, to her time as a partner in private practice, and then continuing on to what she believed would be her final role, as an immigration judge, only for her to choose to depart 18 months later. We then discussed what I believe one of the more fascinating immigration groups at the moment, the Roundtable of Former Immigration Judges and BIA members. Ms. Shugall now serves as managing attorney for immigrant legal defense in the San Francisco Bay Area, an organization whose mission is to, quote, promote justice through the provision of legal representation to underserved immigrant communities, end quote. It's not every day that I get to speak to a former judge, so we dove deep into some issues of immigration law, too. If EYR will permit my discussion with any current immigration judge or BIA member, I promise you, you won't regret it. Full editing rights. Please hit me up, Director Neil. Now, for my interview with former immigration judge Ilyce Shugall. Thank you so much for being on the Immigration Review podcast. How are you doing this evening?
I'm doing well, thank you. How are you?
I'm doing very well. And as I said at the intro, Judge Shugall is a former immigration judge, but she has instructed me, nay, she has ordered and adjudged me to call her Ilyce. And so that is what I'm going to do, even though my former attorney advisor and judicial law clerk, Kevin, is dying inside as I do it. For the record, is that still okay?
For the record, that is appropriate.
Because Ilyce is currently in private practice, and so things have changed.
Nonprofit practice.
Nonprofit practice. And so she goes by Ilyce now. And we're going to get into all of that. So Ilyce, again, thank you so much for taking the time to be on the podcast with me. I'm in San Diego. You're in Los Angeles?
I'm in the Bay Area.
You're in the Bay Area.
Yes, our office is in Oakland.
As with so many guests on the podcast, Ilyce, you and I have never met. We've never met in person. So I'd like to get to know you before we start talking about all the things I want to talk about. I think everybody wants to know you. Who are you? What do you do? How are you doing? Give us everything.
Well, my name is Ilyce Shugall. I am an immigration attorney. I'm also an ultra distance runner. I have been practicing immigration law since 1999. So it's been a very long time.
An ultra distance of practice, if you will.
Exactly. It feels like forever at this point. I started my career at ProBar in Harlingen, Texas. I was an Equal Justice Works Fellow at ProBar for 2 years when ProBar had a staff of 3 people. It has grown significantly since then. Yeah, and then from pro bar, I went to private practice. I was at Vanderhout for 10 and a half years, then went back to the nonprofit world, then became an immigration judge briefly, unfortunately, during the Trump administration. The timing was not planned that way. And then I left and returned to the nonprofit world. And so here I am.
I kind of got my start at pro bar as well, not nearly like you working for them, but when I was a law student at Boston University, they take a spring break trip to pro bar in Harlingen every year. And I was barely into immigration at all. And there I was in Harlingen working on a Nepalese asylum case. And I was so excited. I'd never dealt with an asylum case in my life. And it was 2012. And I actually called the State Department to try to get an opinion specific to my Nepalese asylum client who feared the Maoists, because I figured, of course they're going to do this. Of course they're going to help out this individual who's fleeing the Maoists. And, the state actually got back to me via email like 4 months later saying, we can't do anything, but good luck to you. And here's the country condition report.
Yeah, I recruited my immigration clinic professor from law school to come down with a group of students when I was working there on their spring break.
You didn't go to Boston University, did you?
No, I went to DePaul in Chicago.
Okay. Be very weird if it was the same professor. Well, very cool. What has changed in immigration law since 1999? You don't have to answer.
It just keeps getting worse. There is very little that has improved in immigration law, unfortunately, since I started practicing. I would say the only thing that stands out to me that has been an improvement is DACA.
Which is barely immigration law.
Right. And barely hanging on.
What about criminal immigration law? It seems like the categorical approach has actually sharpened its edges in a non-citizen favorable way in the last 25 years.
I'll come back to that in a second. One thing I'll say in the criminal realm that's been interesting, but also really sad to see is, so I started practicing in 1999 and saw the Supreme Court come down with St. Cyr, saw the Supreme Court come down with Zidvitas, two really monumental decisions. And then I moved to the Ninth Circuit and saw the detention litigation in the Ninth Circuit really move in a really positive direction. The Ninth Circuit detention cases became really positive. And then unfortunately, in the last couple of years, it's really turned back. And unfortunately, the Ninth Circuit has really taken back a lot of the rights that it provided to individuals in detention, particularly prolonged detention.
Yeah.
So that's been sort of an interesting trajectory to watch, but also depressing. But like you said, on the categorical approach, that has definitely improved. I do remember, for example, having to do matter of Silva Trevino hearings in immigration court where we were basically re-litigating the criminal case. Wonderful when that stopped. So yeah, it has been nice to see some positive changes in the criminal context in terms of the categorical approach.
God bless Justice Stevens and Justice Kennedy's concurrences. The Ninth is really interesting, though, because I think I read the decisions every week. The Ninth, as we sit here right now, they actually haven't published an immigration decision in 3-4 weeks. That's unheard of in the Ninth Circuit of old. And I believe that they were saying towards the end of the Trump administration, the Ninth Circuit was about 50-50 on the political party that had appointed that judge. So the Ninth Circuit was about to flip from Democratic appointee to Republican appointee. But some of these recent Trump appointees to the Ninth Circuit really do seem like they have an agenda when it comes to immigration. I don't necessarily say that in a bad way. I really mean they care about this issue, and some of their decisions are really harsh and sometimes mean. And it seems that behind the scenes, there might be a bit of a war going on at the Ninth Circuit in regards to immigration. And I have no proof for this. I just try to read the tea leaves and try to explain why the Ninth doesn't publish as many immigration decisions anymore. Because it seems like when they do, then some other judges come back and publish some really non-citizen adverse precedent.
I think you should interview a former Ninth Circuit staff attorney and get the inside scoop.
They don't speak. We know Mark Vanderhood. His law firm is great. Ira and Mark, I think, go back to about 1935 together when they started working with one another. I mean, Mark's the best. What was it like working for the Vanderhood law firm? What were they like?
I worked there for 10 and a half years. I was a partner my last 3+ years. So I worked for Mark and then I worked with him as his partner. I did learn a lot in the 10 and a half years I was there. I certainly learned how to litigate. I learned how to write. I learned how to handle really complicated, challenging cases. When I was at Pro Bar, that's when I started to really get into the intersection of criminal and immigration law, despite the fact that Pro Bar is the Pro Bono Asylum Representation Project, and it was really an asylum program to begin with. But I started taking cases of individuals with criminal convictions, and that's just sort of where that trajectory went. And that's been my area of expertise ever since. I really enjoy those cases. So I got to do a lot of that when I was at Vanderhout, which I really enjoyed. And it was good to have colleagues who also really enjoyed those cases and were really good at litigating those cases. You know, between that and spending 2 years on the border, I feel like that those two experiences really helped shape the immigration attorney I've become.
I can see why. I mean, those are formative experiences that learn very important things about immigration.
I think one of the things I really enjoyed about being at Vanderhout, and one of the reasons I stayed there for so long, was because there were so few other attorneys or firms or organizations that handled cases that were that complicated.
Right.
And when I left Pro Bar after my fellowship and went to Vanderhout, I definitely went there with the intention of only staying a few years and getting back to the nonprofit world. But at the time, there were no nonprofits in the Bay Area doing removal defense or doing crim-im cases. And so I stayed much longer than I had initially planned, and then eventually decided that I really wanted to get back to the nonprofit world and help develop removal defense practice in the nonprofit setting.
So nonprofit, private bar, and eventually you go to the Executive Office of Immigration Review, you become an immigration judge. Before we get to your time on the bench, and I want to talk about it, I mean, what's that like? I mean, I started my career with EOIR, so I know a bit about what it's like on the inside, but I can only imagine that this was your first experience with EOIR on the inside. What was it like to go from public, private, and then into nonprofit, private, and then into EOIR?
It was my first job with the federal government, so it was definitely a change. I was used to some level of flexibility in my work schedule and my work days. That changed significantly when I became an immigration judge. I had a very strict schedule, and this was all pre-COVID, so there was no work from home. Judges did not have laptops. Judges were not allowed to have email on their phones. So one really big difference that was actually amazing was that I couldn't take work home with me. So my time at EOIR was the least I've ever worked in my career. Because I got to work when I was supposed to get to work. I was on the bench. I did my work. I left when I was supposed to leave, and I didn't bring anything home with me. When I went on vacation, I was on vacation. My weekends were my weekends, and there was no work when I was away from the court, which was really nice.
Right. There's advantages and disadvantages to what you just said. We're all serious advocates for our client, but it becomes all encompassing. It takes over everything. And if you're always accessible, then you're always on, even when you're not on.
For sure. And I always found it interesting. So once I started at EOIR, I was worried it was going to be a really challenging transition because obviously I had been an advocate for a very long time before I joined the bench. I think it had been 17 years, but it actually was a pretty easy transition because I had so much experience and I had such a broad experience. I certainly was one of the leading experts at the San Francisco Immigration Court in terms of knowing all areas of immigration law.
Right.
I mean, certainly there were some judges who had been around for a really long time, like, for example, Dana Marks, who definitely knows more than I do. But other than her, there were very few immigration judges who had the breadth of experience that I had. So it just made it a pretty easy transition in terms of being able to do the job. And I also was really surprised because I had heard so many immigration judges say that the job was really hard. And it was really hard because the cases were hard and the workload was really heavy and the cases were really sad and there was a lot of secondary trauma. And I found that it was so much easier than any job I had ever had in all of those respects.
When you're taking on non-citizen clients, I kind of think of it like they're paying you to take on their anxiety. That your case becomes...
They don't pay me.
Right, they don't pay you. But the payment is actually irrelevant. They're hiring you, is the way I should have said it, to take on their anxiety, to be more worried about their case than they are, that you're their attorney. It's a curse. We know how wrong everything can go. We know that the law is often stacked against the non-citizen on their claim. So in that sense, I can see why it might be less stressful to be an immigration judge where you're not taking on that burden. I'm also not surprised to hear that it appeared that you knew more about some areas of immigration law than some of the colleagues on the bench. I mean, it's just not the case that most immigration judges need to know really anything about employment immigration, for example, or the various visas, because those cases just don't come in front of an immigration judge very much with removal defense. And if you're coming from ICE trial attorney straight to the bench or from a non-immigration position to the bench, then there really is a whole area and maybe a couple areas of immigration law that it just never comes in front of you.
Right.
And so when did you become an immigration judge? What month and year?
I started in September of 2017.
September 2017. Right. The Trump administration was already going.
Right. So when I became an immigration judge, it was before EOIR accelerated the process. So I first applied in November of 2015.
Oh my.
Before we had any idea that there could be a President Trump.
November 2015, it took you 2 years to come on board with EOIR?
I applied in November 2015. I had my first interview in April 2016. My second interview in July 2016. I got my conditional offer in September of 2016, pending background checks. And then I started my background checks shortly thereafter. And then my background checks were still pending when Trump was elected.
Oh my goodness. Process alone. And just for all the aspiring immigration judges out there who work private bar or in the nonprofit section, it's not that long anymore? It's not so cumbersome?
It is not that long anymore. And my understanding is the Department of Justice has gone back to doing a preliminary background check and allowing immigration judges to start before the background check is complete. Because for anyone like me who's never worked for the federal government before and never undergone a federal government background check, they just take a really long time.
Yeah.
But there have been various periods when the Department of Justice has done preliminary checks that allowed people to start and then continued the checks while they're on the bench.
So you underwent 2 years of applying. You were clearly serious about being an immigration judge. Is clearly something you wanted to do probably for the rest of your life. But in reality, you ended up being an immigration judge for 18 months. And you've graciously allowed me to ask you questions about this. And in fairness, it's because I think you've written an op-ed in the LA Times about it. I'm going to post a link to it in the show notes so people can read your words for themselves as well, aspects that we won't get to. But why? Why only 18 months after all that?
So you're correct. When I joined the Immigration Judge Corps, I did think that it was going to be the last job of my career. And the first 6 months were fine. I actually really enjoyed it. I enjoyed hearing cases. I enjoyed the variety of work. The San Francisco Immigration Court is great. I really liked my colleagues. And as I said earlier, I really liked the schedule a lot. It was a nice break from what I had been used to. But then the administration started to come down with more and more very anti-immigrant policies. I remember the day I heard about MPP and thought, oh, well, my friends and former colleagues are going to make sure that that doesn't move forward. And was really disheartened when it actually rolled out and MPP hearings started and people started to have to remain in Mexico. I was also at the Immigration Judges Conference in the summer of 2018 when matter of AB was announced. Jeff Sessions actually was the keynote speaker at the conference, which was disturbing. Listening to his speech to the Judge Corps was super disturbing. It was very much him telling us that we were just Department of Justice attorneys, which we knew we were. Immigration judges aren't real judges. They are Department of Justice attorneys. But he wanted to remind us of that and reminded us that we served at the pleasure of the Attorney General and gave us a sense that matter of AB was going to come down later that day. And then I believe it was after the lunch break, one of the assistant chief immigration judges announced the matter of AB decision and read the head notes, and a section of the room stood up and clapped, which was another really horrifying experience. I've never been in a room like that in my career. I'm so used to being in rooms with advocates. I'm used to going to ALA conferences and National Lawyers Guild conferences. And so this experience was really disheartening to me. And that also came around the same time as the family separation policy. And then there were just more and more policies, very anti-immigrant policies, as well as the EOIR director starting to implement quotas and other very specific requirements on how immigration judges managed their dockets and handled their cases. And I eventually felt like I could no longer in good conscience be part of the Immigration Corps and work for the Department of Justice.
Thank you for sharing that. I want to talk about a few parts of it. First, just the legal aspect. You know, I was with EOIR when matter of ARCG was published, and it's not the best written decision on the planet. There's a lot in matter of AB that me, as somebody who represents non-citizens, really disliked and did my best to get around. And I guess my question is your beef with matter of AB the overturning of matter of ARCG, or some of the other stuff that Jeff Sessions believed that asylum law required, or how he wrote it, or all of the above?
So I 100% agree with you that matter of ARCG is not the best written decision, and it's not my favorite particular social group. And yes, I do have favorite particular social groups because I'm a total immigration law nerd.
Right. As for everybody who might not know the background or listen or not even be an immigration attorney, I believe the particular social group in matter of ARCG is Guatemalan women unable to leave their relationship, or is it unable to leave their marriage?
Unable to leave the relationship.
Unable to leave the relationship. So please continue.
So I agree that that particular social group is not great in terms of how it fits within other Board of Immigration Appeals precedent. that delineates the need for particularity and social distinction and not having a particular social group that's circular. So the mere overturning of ARCG or the finding that that social group doesn't actually meet the requirements under precedent wasn't necessarily the part of matter of AB that was most concerning to me, but rather, as you mentioned, other points that Jeff Sessions made in it, his clear attitude that victims and survivors of domestic violence should not be able to get asylum in any situation, his opinion that individuals who were victims of non-government violence or non-governmental persecutors shouldn't be eligible for asylum. That all really came through in matter of AB. His very strong anti-immigrant attitude came through in matter of AB, and he was clearly attempting to really rewrite asylum law through that decision, and then later through matter of LEA 2.
And it's one of the big issues in asylum law. I started my career in immigration court. My early mentors, some of my mentors still are current or former immigration judges. There needs to be a resolution. And personally, I advocate, and I'm sure you do as well, that there should be some path for some victims of domestic violence to get some protection in America. Because what happens is you would get these individuals, usually women, but not always, who would come into before ARCG when, since Kasinga, when there were supposed to be regulations, and now there are supposed to be regulations again. And you would have this individual tell this whole story, this horrible story of something that's happened to them in their country. And at the end of it, you have an immigration judge who just spent the last 3 hours listening to it, who cares about that person. And depending on the case, we'll have to say something like, I'm so sorry about what happened to you. I can't give you asylum under immigration law. And that's a problem. There's something that needs to be resolved there. The H.W. Bush administration resolved it for individuals who didn't want to get forced abortions in China, for example. I mean, asylum law can be amended to assist groups of populations that America decides deserve our protection. It's a hard issue. It's a knotty issue. There's not even really a question there. What are your thoughts on that? Worst kind of question.
I don't know. I don't know what the general population thinks about whether the US government should afford protection to domestic violence survivors. I certainly think we should. I know all of my colleagues think we should. I know many of my former immigration judge colleagues think we should. But I don't have a good sense of what the general public thinks about that. I think the key about domestic violence-based asylum cases is that we're not just talking about individual women who suffer from domestic violence, but rather we're talking about women who come from countries that are very misogynistic, that really treat women as second-class citizens. And so that adds a layer to the complexity of the domestic violence situations for those individuals. And that is why I think it's appropriate for asylum. If someone was applying for asylum based on domestic violence from a country that doesn't have the same gender issues in society, it's probably going to be a much more difficult case.
I guess the better question then, and based on some of the rationale, to be honest with you, in recent decisions, is should the particular social group in matter of ARCG just be Guatemalan women?
Yes.
And then it becomes appropriately an argument about the degree of harm and nexus.
Correct.
But whether the group is cognizable shouldn't be the battleground.
Correct. And that is how I tended to adjudicate cases, and that is how I litigate most of my cases.
Well, then, to play the devil's advocate, to use a horrible cliche, Attorney General Sessions issues matter of AB. Matter of AB, it's like 18 pages, single space. Like, I get lost reading that decision, and I'm happy I don't have to read it anymore and get around it in my briefs. But I don't read AB as precluding a finding that Guatemalan women is a cognizable particular social group. You might have issues on particularity, but that certainly doesn't come out and say it. And you're not doing anything insubordinate. That is the beauty of case law. Case law is open to interpretation, and dicta is dicta. Doesn't the immigration core need a broad swath of individuals with judicial philosophies on all issues, including the scope of matter of AB?
It does. And that was something that I really struggled with when I was deciding whether or not to resign, because I was resigning during the Trump administration, and I knew who the Trump administration was hiring as new immigration judges. Mostly people without any immigration background, a lot of people from the military, a lot of former US attorneys, people who had very different views and backgrounds than I did. And so that was something that I thought about a lot when I made the decision to leave.
You finish your LA Times piece by saying, quote, "The immigration courts will be subject to politics driving the administration rather than the principles of justice immigration judges are sworn to uphold," end quote, unless the immigration judge corps become Article I judges, which essentially would take them out of the purview of the attorney general and make them more akin to bankruptcy judges, drug court type judges. But why do you think making the immigration judges Article I judges will resolve a lot of the issues that led you to leave EOIR?
So as you mentioned, the immigration court is within the Department of Justice. The Department of Justice is a prosecutorial agency. The Attorney General is the lead prosecutor of the United States. Having an immigration court within a law enforcement agency is problematic. In addition, the Attorney General is appointed by the president. And so we've seen over the years, and I've seen over the course of my career, sweeping changes in the immigration courts, in immigration court priorities, docket priorities, depending on who's president. And that's a real problem. And I will say, I didn't go into the job naive. I knew that. I'd been practicing for a really long time. So I saw different administrations do different things with the court. But I will say that the Trump administration did a lot more during the 4 years Trump was in office than most administrations did. So I think it was just really unfortunate timing for me, and I really felt it. But I think it is really crucial to have an independent immigration court and not have the whole court system subject to the whims of the politics of an administration or the opinions of the attorney general at the time.
Right. It's for that reason that other courts and other judges they are real courts. They do have independence. I mean, there's a reason for that. We're
exactly.
We're kind of discussing something that the founders really resolved 250 years ago, or however long it's been.
It's better now than it was pre-Department of Homeland Security, when you had both INS and EOIR within the Department of Justice. So then you really had the prosecuting entity and the immigration court both part of the same Department of Justice. So it's marginally better now because the prosecuting entity is within DHS and the immigration court is within DOJ. Nevertheless, the immigration court sits within a prosecutorial agency.
And now, a word from our sponsors. This podcast is sponsored by Journey Business Plans. Journey is the leading business immigration plan writing company in the United States. 10 years. And they know immigration. Heck, they started as an E2 company themselves. Journey prides itself on its responsiveness and overall customer service, preparing business plans for E2, EB2 NIW, L1, EB5, and much more. If you don't yet know about Journey and don't want to listen to just me, ask your colleagues. Or even better, try them out. Visit www.journey.com and use promo code REVJOURNEY30 for a 30% discount on your first business plan. That's REVJOORNEY30. Or click on the link in the show notes. I think by my count, the Trump administration, through 4 attorneys general, which include maybe 5, including temporary AGs, issued like 15 decisions in 4 years, 15 precedential decisions, including at least 1 and maybe 2 lame duck decisions, which includes matter of AB the second, which just goes back to show how complicated it is that they needed to do it again with Attorney General Rosen, I believe. But 15 in 4 years. Whereas the Obama attorneys general, I think, issued about 4, maybe 6. And the same thing is happening with Attorney General Garland, where those decisions really just kind of vacate what their predecessor has done. Attorney General Garland has also issued matter of BZR, which essentially vacates what the BIA has done. But there hasn't been a single decision out of Attorney General Garland, and I believe the Obama attorneys generals, that actually advances the law in any direction. It's reactionary when there are Democrat presidents. I don't believe Attorney General Janet Reno did anything in that regard either. And so if you have one political party that comes into power and issues, and I might be wrong on Attorney General Janet Reno, it's been, I was young, but if you have one political party that comes into power and rewrites immigration law through presidential attorney general decisions, and then another party that comes in and vacates a couple of them and does nothing, then you have a clear trajectory on where immigration law progresses. But at the same time, you don't want one every 4 years, 15 decisions that are completely opposite being issued by the attorney general. So I don't know how to resolve that when you're still having attorney general presidential decisions.
Right. It's a problem. The other thing that I think is really problematic that we don't talk about enough is just the priorities of the court. Because we're now at a place where the immigration court has a growing historic backlog. I don't even know what it is at this point. Obviously, well over 1.6 million.
9.5 trillion, I believe, is the official.
Right. Sounds
estimate.
right. Sounds right.
Just going to say that.
But each administration has different priorities, and then they set out their priorities and they move dockets around. And it just creates total chaos in the dockets. It forces people who've been waiting years to wait even longer. And then it forces people who can't find representation to move forward quickly. And it's not fair to anyone involved. It's not fair to the respondents appearing in court. It's not fair to the ones whose cases are expedited. It's not fair to the ones who've been trying to get their day in court for a decade or more. It's not fair to practitioners, and it's not fair to immigration judges.
Mark Vanderhout is listening somewhere saying, preach, because he's litigating a case that you probably took 20 years ago. That's still pending in San Francisco.
It's true. It is definitely true.
As always, this will be edited, but we are currently 53 minutes into this interview, and we haven't even talked about the thing that I wanted to talk about, which is just a testament to hopefully how good this interview will be and how helpful it'll be and beneficial to listeners. But I want to talk about the amicus group of former immigration judges and BIA members, the amicus roundtable. I've talked about it on the podcast every time the group issues an amicus decision in a case.
Amicus brief.
Amicus, did I say decision? It's a Freudian slip. Issues a amicus brief in a case. What is going on here? You're a member, obviously. That's why I'm talking to you about it. But what is going on? This thing just seemed to spring out of nowhere in a decision a couple of years ago, and all of a sudden, here are all these former IJs and BIA members speaking in court. Well, what's going on with this group?
It's a great group. So we call ourselves the Roundtable of Former Immigration Judges. Former immigration judge Jeff Chase started the group. And he really started super informally. He got a few colleagues together to sign on to 1 or 2 amicus briefs. And then during the Trump administration, a large number of immigration judges retired. So many judges who were reaching retirement age anyway decided to retire earlier than planned because they didn't want to be working at the immigration court in the Trump administration. And then there were several of us who resigned. I wasn't the only person who resigned because of Trump administration policies. And so because there were such a large number of people leaving the bench, Jeff Chase started reaching out to everyone, and the group became a bit more formal. And as more people joined the group, we were getting more requests to weigh in on cases at all levels. We've filed amicus briefs in district court, at many of the Court of Appeals, and the Supreme Court. I think we also have done amicus briefs at the BIA. And then after I joined, I also helped get us organized to do comments to many of the proposed regulations during the Trump administration.
Very interesting. That's an unknown aspect of it to me. What is an amicus brief for everybody who doesn't know?
It's a friend of the court brief. So it's a brief that's written from the perspective of the group or entity that's writing it, weighing in on the issue before the court. So when the Roundtable of Former Immigration Judges is asked to do an amicus brief, we have a small subcommittee because there's now over 50 members of the Roundtable. So we had to create a small group that makes decisions and does the lion's share of the work. So when someone comes to us with a request to do an amicus brief, the subcommittee gets together and thinks through what the former immigration judge's perspective or former BIA member's perspective would be on the issue. And we think through whether it's appropriate for us to weigh in, whether we have a unique perspective on that issue. And then if we do, then we do an amicus brief.
What kind of issues does the group generally believe it has an expertise or something to offer in such that it'll sign on to an amicus and you don't have to answer if you don't want to?
A lot of the issues have to do with our perspective on how immigration judges adjudicate cases. There have been some that have to do with assessing evidentiary issues and how immigration judges do that. They tend to be issues where we can come from a very specific perspective. For example, we did one on a mental health issue and what our perspective was on assessing a mental health issue in immigration court.
Which actually is a bit ironic because I had former immigration judge DiPaolo on the podcast early on from Otay Mesa, who is the immigration judge on matter of GGS, who never wanted that to be the decision, who disagrees with the BIA GGS decision, who wanted to consider mental health factors in the particularly serious crime analysis. And eventually, 6-7 years later, Attorney General Garland says you can do that. And here we are. There's a whole immigration judge group now that says, that would be helpful. It's interesting because so often on the bench, there's a whole litigation about it. Immigration judges aren't allowed to speak because when they do speak, they speak for EOIR too often, and it's dangerous. There's pros and there's definitely reasons for it. But now here you are, all of you, no longer with EOIR, certainly finding your voice. What are the Roundtable's plans for the future?
We have made some efforts to try to formalize our processes more. We continue to be a very informal group. We are not a 501c3. We're not an actual organization. We don't have a bank account. We don't have an office. We don't have any of those formal things. We have talked about trying to do some of those things, but so far that hasn't happened. And for the most part, it works. We have had some help with getting our briefs organized and our comments organized so that they're easier to find. But I think for now, the future is that we're going to continue to weigh in on issues that we think are important, where we think we have a unique voice and perspective. And maybe one day we will become more formalized and become a nonprofit organization, to be determined.
Well, I say keep it up. All of us kind of who did not agree with the Trump administration on immigration did things in our own way when he came into the presidency, essentially saying that he was trying to deport Muslims. And I think it's cool that the former immigration judges and BIA members also decided to do something.
Thank you. Yeah, it's been a really good experience. And I will say we've had many courts cite our amicus brief and their opinions, which has been very rewarding and good to see.
Last question on the issue, but I don't want to undermine the group's credibility, but do you meet around a round table? Or because if not, you guys aren't really being completely honest with the courts.
We do not.
Wow.
And in fact, since I joined, we have never all met in person.
Don't even say that there's not even a table.
There's no table.
Oh my God. Oh my goodness. I think you guys need to apologize to the courts. You should call yourself the former immigration judge and BIA Zoom group.
Right.
Fraud on the courts. We've talked a lot about your past, some about your present with the roundtable, but what are you currently up to for your day job?
I am managing attorney at Immigrant Legal Defense, which is a nonprofit immigrants' rights organization based in Oakland, California. We are a group of very experienced attorneys, and we handle a variety of cases. I personally continue to do a lot of removal defense cases, largely cases involving criminal issues, detention issues. I also am one of the attorneys in my office who handles National Qualified Representative Program cases, or NQRP cases, which are cases where counsel is appointed for people who are found mentally incompetent to represent themselves. I was the first qualified representative in the San Francisco Immigration Court when the program started.
Oh, wow.
So I've come back to it. I'm doing those cases again. But I also do some affirmative work. I do a lot of U visa work, some VAWA, and then a sort of smattering of other affirmative cases. I do some appellate work. I have a very broad caseload. And then in addition to doing casework, I do mentoring work. So I currently do mentoring for Community Legal Services in East Palo Alto, which is the organization I worked for before I became an immigration judge. I help mentor and supervise some of the attorney staff there, and I've done some other consulting work for other organizations.
Seems like you're exceptionally busy. How did it feel to go back into that world after you left EOIR? Was it a relief? Was it daunting? Was it sad? Was it everything? What was that like? I don't think there's many who have done that.
The transition has been good. I am currently working with many close friends and colleagues at ILD. The staff at ILD consists of many people who I've known and worked with and been friends with for years. So it really is a wonderful environment and really great to be working with people who I trust and admire and really enjoy working with.
Well, as a member of the private bar, I'm glad you're back. And what you didn't mention is you're also a commissioner on the ABA Commission on Immigration, as I am recently, and it's really cool. And that takes us full circle because they're also, kind of the governing entity of which ProBar is part of. So it's really full circle for you on that to now be on the other side where you started.
It is, and I'm probably going on the ABA Commission's pro bono trip to ProBar in the spring.
Enjoy Harlingen. I'm not sure if I'll be able to make it.
You should. It's such a fun place.
Don't tell Meredith. We'll really know if she's listening. Ilyce Shugall, Judge Shugall, thank you so much for spending your evening with me tonight. Nobody else can see it, but I can see it through our video right now. It looks like you've got a lovely backyard. So enjoy that. Have a great dinner, and thank you so much. I hope to meet you in person someday.
Thank you. You have a good night too, and thank you for inviting me.
So there you have it. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate for 5 credit hours, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all. And follow the show on Instagram and Facebook at Immigration Review, and send us a tweet at ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.